A very warm welcome to all of you in this second session of Art of Reading Companies Act 2013 and Basic Charter Documents. I'm CS Shruti Soni, and in this video, we are going to discuss mainly about Articles of Association and the provisions relating to its alteration and entrenchment. So let us continue. Now, as per Section 2, subsection 5 of the Companies Act, we all know that articles means the articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this act. So, articles are basically the articles which are either originally framed or which may be amended from time to time also, whether it is under the previous company law or under the new act. Basically, what do the articles contain? The articles contain rules, regulations, bylaws, and they are mainly for the internal management of a business of a company, right? They establish a contract between the company and the members and between the members inter se. So it's basically a contract between the company and its members and amongst the members also, if we say that it plays the role of a contract. This was very aptly held in the case of Naresh Chandra Sanyal versus Calcutta Stock Exchange Association Limited, right? Now, Section 5(1) of this Companies Act, it provides that articles of a company shall contain the regulations for management of a company, and it may also contain such matters as may be prescribed. So we have rules for this, right, in which the matters are contained. Apart from that, the basic premise of this is that they will contain the regulations for the management of a company. Okay. Nothing prescribed in this subsection shall be deemed to prevent a company from including such additional matters as may be considered necessary for its management. So, apart from these things, if a company feels that a particular provision is necessary for it, then it may incorporate that also in its articles. There was no such parallel provision in the Companies Act 1956. This is a new insertion, right? Now, there are certain model forms of articles which have been specified in Schedule 1 of the Companies Act. And this is basically Rule 11 of Companies Incorporation Rules, which guides this. So, we have Table F, which is a model form of articles for company limited by shares. Table G, which is for company limited by guarantee and having a share capital. Table H is for company limited by guarantee and not having share capital. Table I is for unlimited company having share capital, and table J is for unlimited company and not having share capital, right? So these are the model form of articles which have been specified in Schedule 1. A company can directly incorporate this or it can handpick the provisions from these articles, okay? Now, there is a stipulation in Section 5, subsection 7 of the Companies Act. What does it say? It says that a company may adopt all or any of the regulations contained in the model articles. So, just now you saw that there were some model articles. You can adopt all the provisions given in that, depending on the type of your company, or you can handpick the regulations, right? However, there is another provision which is given in Section 5, subsection 8, which says that if the registered articles of a company do not exclude or modify the regulations contained in the model articles, you either do not exclude them or do not modify them, then it shall be presumed that they are applicable to that company as if they are contained in the duly registered articles. So, if you really want to exclude something, you have to do it explicitly, right? Now, articles and amendments are binding on the members, right? The members can't say that we were not a part of it or while this resolution was being passed, I was not there. It is very clearly held in TCS versus Cyrus Investment Private Limited in 2021 that articles as well as the amendments, they are binding on the members, right? Even if there is an amendment which is made after a person becomes a member, he is bound by alterations. But yes, we cannot increase his liability towards the company without his consent. We need a proper written consent. I've discussed that later also, right? So amendments as well as articles are binding. And even if it's like proposed after I become a member, I'll be bound by it. Except it is about increasing my liability. Now, this is a very practical situation wherein we have certain financial collaborations, right? So whenever there are financial collaborations or joint ventures between two companies, the parties come together and they enter into MOU or private contracts, okay? Most of them sometimes relates to appointment and ratio of directors, appointment of chairman, then powers to be exercised by each party, voting rights. So they have different provisions, right? Now, these private agreements are not binding on the company unless they are incorporated in the articles of the company. Various judgments have said this, and even the Act gives us a legal recognition that once these private agreements are incorporated in the articles, only then will they bind the company, right? And this is very important because many companies enter into these kind of collaborations and they have to do this for their no safeguarding their own interests. They have to enter into these kind of private agreements with certain safeguards. Now, this is a similar matter. Mafatlal Industries versus Gujarat Gas Limited. This is a case of 1998. In this case, there was an agreement between two branches of a family, right? They had an agreement that they will have equal number of shares. This agreement was not incorporated in the articles, right? So there was a private agreement, but it was not incorporated in the articles. Members of family of one branch, they wanted to transfer his shares to members of a family of another branch. So they wanted to transfer their shares to the other branch. Now, it was held that the company was bound to register the transfer of shares as the agreement was not incorporated in the articles. That means if I want to transfer the shares to you, the company will not be restrained saying that these two branches will have to have equal number of shares because there's a private agreement. They could have done had the private agreement, they had got it incorporated in the articles. But as they did not do so, this agreement was not binding and the company had to register the transfer of shares from one branch of a family to the other branch, right? Now, in Vodafone India Private Limited versus WPI Group, it has been held that the shareholders agreement, if not incorporated in the articles, same thing, is not enforceable even if it is not against Companies Act. Okay, so you can't take this plea that, sir, what is the problem in this shareholders agreement? This is not against Companies Act. No, the only problem is that it should have been incorporated in the articles. Fine. Now we also have to keep in mind that articles are subordinate to the memorandum of association. Fine. Articles cannot contain any provision which is against the Companies Act or the memorandum or the law of land or public policy. So while framing the articles, we have to keep this point in mind that they are not subordinate to memorandum. I'm sorry, they are subordinate to memorandum. That means they will not prevail above it. Okay. They will not go against whatever is given in the memorandum. They will not go against whatever is given in the Companies Act or against the law of land. Usually, the matters which are contained in articles relate to, amongst other things, I've just handpicked a few of them which are important ones: alteration of share capital, buyback, voting rights, proxy, winding up accounts, then procedure of general meetings, etc. Right? Now, what is the effect of memorandum and articles? Let us do that now. Section 10 of the Companies Act is very clear that memorandum and articles of association are binding. Okay, they have a very binding effect on whom? On the company also and its members also, right? So whatever we incorporate in the memorandum and articles, we have to do it very carefully because it will remain binding on the company also and its members also, as if it is signed by the company and each member. So maybe I have not signed it. I became a member later on, but that does not preclude me, right? So the same situation will be there as if I was original member, and they are bound to observe all the provisions of memorandum and articles of association. So this is the binding effect which is very clearly mentioned in the Companies Act. So each member must follow and abide by the provisions both of articles and memorandum. You can't say, sir, this is okay and this is not okay, or either ways, because articles will have whatever the memorandum clearly states. Okay, articles will have an offshoot of that only. It can't go beyond that. Now, company can also sue the members. for enforcement of its articles as for restraining their breach. So if the company feels that the articles are not being complied with, any provision is being breached, the company also has legal remedies for that. Okay. The company is bound to members not only as a body, but also to individual members to follow the provisions of the articles and the memorandum. Now, what does this mean? That means the company will ensure that the members, not as a whole, are following it. Okay, one or two are not following it, it's okay. No, it's not okay. Even individual members and the members as a whole, they are supposed to follow the provisions of the articles as well as the memorandum, right? A member can also sue the company. For what? For protecting the membership rights, which are given in those documents, right? So member can also sue the company to protect their membership rights, such as right to vote, right to receive dividend, attend meetings, receive notices, etc. Fine. So member can also get his membership rights protected. But please keep in mind that this can only be in his capacity as a member. He cannot sue in any other capacity to enforce the articles. Correct? I hope this much is clear. Let us proceed. Now, in this case, as you can see on the screen, Woods versus Odessa Water Works 1889, the articles of a company provided that the directors may, with the sanction of the company at a general meeting, declare a dividend to be paid to the members, right? So what did the articles say? That the directors may, with the sanction of the company at a general meeting, declare a dividend. Fine. This was given in the articles. Now, a resolution was passed that what will the shareholders get? Interest bearing debenture bonds. Okay. Not dividend. It is, what is this? Interest bearing debenture bonds. They'll be redeemable at par by annual drawings over 30 years. So instead of paying them dividend in cash, this was a resolution which was passed by the people there, right? Now, a member filed a case restraining the company from acting as such because this was not in accordance with the articles. What did the articles say? You need to pay dividend. So this was very much adhered to, and it was declared that yes, dividend had to be paid in cash because that is what articles are providing. So, a member can get his or her rights protected as long as there is a provision in the articles and as long as he's acting in the capacity of a member, right? Now, articles and memorandum, when registered, they do not create any contract between the members of the company inter se. That means whenever, especially memorandum, whenever it is registered, that does not mean that the members are entering into a contract. A member can also not sue any other member for a wrong done by him to the company. Okay, a member cannot sue other member for a wrong done by him to the company. He cannot even recover any money which is due to the company. Okay, the only exception is under which even an individual shareholder may sue in his own name to enforce his individual rights. And what are those exceptions? When the acts complained of are completely illegal or they're ultra vires the company, or when the wrongdoers are in control of the company to that extent that they will not permit an action to be brought against them in the name of the company. Okay. So usually a member cannot sue any other member, but only these two kind of exceptions will prevail, right? When they are illegal, when the acts are ultra vires, and when the wrongdoers are in so much of a control that they will not permit an action to be brought against them in the name of the company. Now, another important thing in this is, while we're talking about effect of memorandum and articles, is that an outsider cannot take advantage of the articles or memorandum of a company. Okay. So outsider will always be a stranger to the contract and he cannot take advantage of the articles and memorandum. And very clearly mentioned that they do not confer contractual rights upon outsiders against the company or its members, even if the name of the outsider is mentioned in the article. So even if a person's name is mentioned, you cannot say that this is equal to a contractual right with the outsider and he cannot take benefit of that. Clear? Now, this is a similar example for this, a case, Brown versus Trinidad, in which the articles of a company, they contained a clause whereby B was to be a director of the company, okay? And he could not be removed for a period of time. However, he was removed from office before the period expired. But in this case, it was held that B could not restrain the company from removing him. That means he could be removed, even though the articles contained a clause whereby he had to be a director, but then there was no contract between him and the company. Just because his name was mentioned, just because it was specified it is going to be for this particular period, you can't say that the company cannot even remove him, right? Now, how do we alter the articles of association? Can we do that? Yes, we can do that. We can do that with the help of section 14. Okay, it's a statutory right and it is provided under section 14 of the Companies Act. What does section 14 say? It says that the company may alter or add to its articles by passing the special resolution subject to the provisions of the act or memorandum. So whatever addition you want to make in your articles or whatever alteration you want to make, you can pass a special resolution. However, that shall be subject to the provisions of the act and subject to the provisions given in the memorandum. You can't go beyond that, or you cannot add anything illegal, right? Then you cannot even say that, we will not alter the articles. Okay. So no company can deprive itself of the right by entering into a contract or including a statement that they cannot be altered. So it's a statutory right. You can alter the articles with the help of section 14. What does it say? Special resolution, right? Now, this is a very important concept which we are now going to discuss. This is entrenchment provisions in the articles, right? Now, what does the word entrench mean? Entrench means to place oneself in a position of great strength or security, right? Now, in case of joint venture agreements, the joint venture partner wants to keep some power so that his interests are protected. And often such restrictions are found in the articles of associations of such companies, right? However, in many cases, the court has held that any provisions in the articles against the company law are void, and this has led to a number of disputes. So we need to have certain safeguarding provisions, and that is why the role of entrenchment provisions comes into picture. So Section 5(3) of the Companies Act clearly states, now what does Section 5(3) clearly state? That articles may contain provisions for entrenchment to the effect that the specified provisions of articles may be amended only if conditions more restrictive than special resolution are complied with. Okay, so what does it say? Let us understand it. Section 5(3) says that, okay, articles may contain provisions for entrenchment. That is, if you want to place yourself in a stricter position, you can do that. Now, what is that? You can say that a particular provision of the article can be amended only if a more strict condition is followed. That means we need something more than a special resolution, right? Now, these kind of provisions you can incorporate in the articles both at the time of incorporation and you can even add them subsequently, right? But of course, subsequently, if you do that, you'll need to alter the articles which you had originally framed, right? Now, this kind of amendment, if you want to add in your articles, this can be done only if it is agreed upon by all the members, if it is a private company. And this can be done by a special resolution in the case of public company. So if you want to add those stricter provisions, you'll have to comply with Section 5, subsection 4 of Companies Act, which says that if it is a private company, then all the members have to agree to this more restrictive clause. And if it is a public company, then it has to be complied by a special resolution. Now, when the articles contain provisions for entrenchment, either it is at the formation stage or by amendment, the company shall give notice to ROC in the prescribed form. That means the ROC has to be informed that, sir, our articles have this kind of an entrenchment clause, and this is given under Section 5, subsection 5. Now, when the articles contain the provisions of entrenchment, the company shall give notice to the registrar. In which form? Spice Plus, that is your simplified pro forma for incorporating company electronically, INC 32, along with fees, and this is at the time of incorporation, right? That means whenever you do this at the time of incorporation, you have to comply with this provision, correct? In case of existing companies, it shall be filed in form MGT 14 within 30 days from the date of entrenchment of articles along with fees. Okay, this is provided in companies registration offices and Officers Fees Rules 2014. And this is in pursuance of Rule 10 of Companies Incorporation Rules 2014. Now, this MGT 14 form has to be filed by the company, provided it is not an OPC or a small company. MGT 14 has to be pre-certified by a practicing CA, CMA, or company secretary. And this is in pursuance of Rule 8, 12A of Companies Registration Offices and Fees Rules 2014. Okay, so MGT 14 has to be pre-certified by a practicing professional. Now, here is a case of Gaja Trustee Company Private Limited versus Haldia Coke and Chemicals 2018. Now, the articles in this company's case required affirmative vote of shareholders in certain matters, right? That is, the shareholders had to agree to a particular matter and only then it was supposed to be cleared. And this was mentioned in the articles. It was held that a resolution of board of directors in such specified matters without affirmative vote of members is invalid. So what they had done was that they wanted some more levels of approval. However, the board only gave its approval. So it was held that without the affirmative vote of members, the matter cannot be proceeded with, and the matter actually pertained to application to NCLT for corporate insolvency resolution process by the corporate applicant. Now let us take a look at some of the important points to be kept in mind while altering articles of association. Some important points which you should not forget while altering the articles of association. Let us go through them first. The articles must not exceed the authority, and the alteration should also not exceed the authority. The alteration should not be in conflict with any of the provisions of the memorandum also. In case there is any conflict, then we have to keep in mind that the provisions which are given in the memorandum shall prevail. Okay. So whatever we alter, we have to keep in mind what is given in the memorandum, and accordingly we have to make the alteration. Similarly, the alteration of articles cannot be inconsistent with the provisions of the Companies Act. Okay. The alteration of articles has to be in consonance with the Companies Act. You cannot, alter articles to call reserve capital anytime. We know that reserve capital can be called only at the time of winding up. So just because I'm putting that in articles as an amendment doesn't mean that the amendment will be effective. Okay. Similarly, the articles as well as the alteration, of course, must not include anything which is illegal or opposed to public policy. Correct? That means if everything was legal prior to the amendment, I cannot make it illegal by a subsequent amendment. Okay? And though I follow the procedure, I can't justify myself, sir, I followed the right procedure. The only thing that I did was to add an illegal item. I can't do that. Okay? Now, the alteration must be bona fide, and the main crux should be for the benefit of the company as a whole. I can't just simply say that this alteration was necessary for me as an individual or we both as people. Okay. Alteration must not constitute a fraud on the minority by a majority. So we have to keep in mind that it should not be oppressive. It should be for the benefit of the company as a whole. It should not have any malified or any ulterior intentions. Okay. Now, another important thing, as we know, NCLT has got very important parts. So if there is an application under Section 242 with respect to oppression and mismanagement, we know that NCLT has got wide powers. Under that section, NCLT can, in certain cases, it can order amendment also, both to the memorandum as well as to the articles. Okay. Now, if NCLT passes some orders, and if through its order the NCLT has ordered you to alter your memorandum and articles, then subsequently you cannot alter the memorandum articles again, which are inconsistent with whatever the orders of NCLT. So if NCLT has ordered you to change certain things, you change them and then subsequently you alter your articles changing the, coming back to the previous situation or coming back to another situation which is to your benefit and which is going against the NCLT's orders, that is not permitted. Okay. So this is given under section 242, subsection 5. Now, this partly we have done previously also. Let's do that in detail now. Any alteration which compels an existing member to take or subscribe for more shares or in any way increase his liability to contribute to the share capital without his written consent to the same is invalid. So if there is any alteration which says that you are an existing member, but we have altered the articles to that extent that you have to subscribe for more shares now, or you have to pay more money, and your consent is not required. No written consent will be taken. We have altered. So this is not a proper valid alteration. Okay. However, please keep in mind that this kind of a consent, which we have mentioned in the first case, is not required if the company is just a club or association, and the alteration merely requires him to pay recurring or periodical subscriptions at a higher rate. So if the monthly charges which you are charging from a member of a club, if that you have increased, in that case, this kind of a provision is not required. Okay. Now, section 15, subsection 1. That is also very important. We should remember that whatever alteration we make in the memorandum or in the articles, we have to note that in every copy of the memorandum or articles as the case may be, right? So it has to be noted in every copy. In case there is any default, then we invite the provisions of section 15, subsection 2, which says that the company and every officer who is in default, they shall be liable to a penalty of 1,000 rupees for every copy of the memorandum or articles which has been issued without such alteration. So the number of copies in which you have not complied, just multiply that with 1,000 and that will be the amount of penalty for which the company and every officer who is in default will be liable. And this provision is contained in section 15, subsection 2. Okay, this is with respect to the previous section which I mentioned here, section 15, subsection 1. That is, every alteration made in the memorandum or articles of a company shall be noted in every copy of the memorandum or articles as the case may be. Fine. Now you can use the alteration to convert a company, private company into public company, of course, with other procedures to be followed. But keep in mind that if your company is having more than 200 members and then you are passing a resolution of conversion of a public company into private company, then it has to comply with the postal ballot requirements also. Okay. In Cyrus Investment Private Limited versus Tata Sons Limited in 2019, it was held that if a company decides to alter its articles having effect of conversion of a private company into a public company or a public company into private company, then it has to pass a special resolution for the alteration, as well as it will require approval by the tribunal also. Okay. Now, memorandum versus articles. You must have read at many occasions also the same thing, but I've just tried to incorporate the most important differences between the memorandum and articles so that we are clear about what these two documents actually specify. Okay. So memorandum basically defines and delimits the objectives of a company, whereas articles, they lay down the rules and regulations for the internal management of the company. So here we are talking about objectives and here we are talking about rules and regulations. So what do the articles basically do? They basically determine how the objectives of a company are to be achieved. So we should be crystal clear about what role memorandum plays and what role articles play. Now, memorandum we have to keep in mind is subordinate to Companies Act, but it lays down the parameters for the articles. That means the boundary within which the framework of the articles shall lie is specified by the memorandum primarily and of course by the Companies Act to which even the memorandum is subject to, right? Now, articles are subordinate, as we know, to both the memorandum and the Companies Act. So, articles cannot say, I've complied with memorandum, let the Companies Act go. No, it has to comply with both. So, one is talking about the objectives, the other is talking about rules and regulations, and memorandum being subject to Companies Act, and articles being subordinate to both memorandum and Companies Act. Now, memorandum basically defines the relationship between the company and the outside world. Okay. It basically defines what is the company's relationship with the outside world, whereas articles basically define the relationship between the company and its members, and of course, the members inter se also. Acts whichever are done by the company, which are beyond the scope of memorandum that we have discussed in the previous session also, they are ultra vires and they are void. Okay, null and void. They have no legal sanctity, and even by the 100% consent of all the shareholders, they cannot be ratified. We have discussed this in detail in the previous session. Now, acts done ultra vires the articles. That means something which is done beyond the articles. Can that be ratified? Yes, you can ratify that by a special resolution of the shareholders, provided they do not go beyond the memorandum. So, something which is not given in the memorandum, if you're trying to ratify that also, you can't do that. For example, if the borrowing powers of the company are specified in the memorandum up to a particular limit, there is a procedural glitch in articles. You can ratify that, but you can't change the whole scenario which is given in the memorandum by a ratification meant to alter the articles only. Okay. Now there is a small but very important doctrine of constructive notice, right? Doctrine of constructive notice was previously followed only on the basis of judicial precedents, but now we have a proper legal sanctity also, which is given here, which is section 399. Now, what does section 399 says? Section 399 is that any person means any person, can inspect by electronic means any documents which are kept by the registrar. So you can inspect them, or you can make a record of them also. Okay. Or you can even get a copy of them or extracts of those documents, including the certificate of incorporation of a company. And this you can do only on payment of prescribed fees. So basically, this section is conferring the right of inspection to all. So how does it relate to doctrine of constructive notice? Now let us understand that. So constructive notice, what does it mean is, you have got this flexibility of inspecting. You can go and check with registrar. You can get a copy of documents. You can get a copy of any extract of a document. You can get certificate of incorporation. So if you can do all this, so whether a person who's dealing with the company, of course, whether a person who deals with the company reads the documents, MOA or A or not, he is presumed to have knowledge. He is presumed. That means it is presumed that he has read them and he is very much aware about the contents of those documents. Okay. And we are very clear about the terms and conditions. That means just the presumption that I have read it is not sufficient. Reading means understanding also, and that too in their true perspective. So doctrine of constructive notice states that whenever a person is dealing with a company, we assume that he has read the documents, he knows the contents, he has understood them, and even other documents such as special resolutions which are required to be registered with the registrar, he is very clear about those contents also. He has not missed them. Okay. So that is what is the meaning of doctrine of constructive notice. Now, doctrine of constructive notice is basically, meant to safeguard. Okay. But there is a negative aspect to it also. And to curtail that negative aspect, we have doctrine of indoor management, right? So doctrine of constructive notice basically seeks to protect the company from outsiders. Whereas we have another doctrine, which is doctrine of indoor management, which seeks to protect the outsiders from the company. Now, what does this doctrine of indoor management say? Doctrine of indoor management basically says that whatever is happening inside the company you can't expect the outsiders to know each and everything. Okay, they at a particular point, they have to presume that certain internal compliances have been carried out. They can't completely get into that investigation whether this happened or this did not happen. Okay, so what we can say is that although memorandum and articles are public documents which are open to public inspection, the details of internal procedure are not open to public inspection. Okay, so we can go, section clearly said that you can go and inspect memorandum or you can go and inspect articles, they are public documents. But after that, whether the procedure was actually followed, whether the meeting was actually held or the resolution was actually passed, that is something which is not available in the public domain and they are not available for public inspection. The outsider may presume to know the constitution of the company. So you can presume that the outsider has knowledge of the constitution, but whatever has happened inside the doors which are close to him, you can't expect him to know that also. So basically, this doctrine seeks to protect the outsider from the company, whereas the doctrine of constructive notice, as I've already told you, it seeks to protect the company from outsiders. Now, this doctrine was first laid down in this case, Royal British Bank versus Turquoise, and that is why it is also known as the Turquoise rule. Now, in this case, the articles of the company, they provided for borrowing of money on bonds. The article said that, okay, the company can borrow money on bonds. However, they will need a resolution which has to be passed in the general meeting. Now, the directors acquired this loan. That means the director went and they took this loan, but they failed to pass the resolution. Okay. The resolution which was required, you can see this, the articles provide for the borrowing of funds, they required a resolution to be passed in the general meeting. So this resolution was not passed. Repayment on the loan was defaulted. Company was held liable. Now the shareholders, they refused to accept the claim. They said, sir, the resolution was not passed, so why should we be liable? But in this case, the company was held to be liable because it was said that the person who is dealing with the company, he was very much entitled to assume that the necessary compliance with regards to the internal management, that is the passing of the resolution in this case, what was stated in the articles, has been done. Okay. So this was Royal British Bank versus Turquoise. Articles providing for borrowing of money subject to a resolution which was to be passed in the general meeting. Borrowing took place, but without that special resolution. Payment was defaulted, and therefore the company was made liable. However, the shareholders, they refused to accept the claim because they said that there was no approval taken from them, there was no resolution. So the company, in spite of this, was held liable because that was a matter of internal management and the outsiders cannot be expected to have knowledge about whether it actually took place or whether it did not take place. Okay. There are certain exceptions also to the doctrine of indoor management. These are very common and they are also very important at the same time. The first point is knowledge of irregularity. Let us take this up. When the person is dealing with a company has notice. So I'm a person, I'm dealing with a company, I have notice. Whether actual or constructed, that means maybe you've actually given it or I've got through some other source of the internal irregularity. That means I know that this particular resolution was not passed, which was required. Suppose in the previous case I take. So I know that this resolution was not passed and still I ignore it. Then later I cannot claim protection, which is provided by this doctrine. So if I have knowledge of irregularity, then I cannot seek protection under this particular doctrine. Okay. Now, this knowledge of irregularity, this can arise from the fact that the person who was contracting was himself a party to the inside procedure. That means maybe I was amongst those people who were supposed to get the resolution, but I knew that this was not done. Still, I wanted to get protection, so I will not get protection. Okay. Now, in the case of Morris versus Cancin, this is stated very clearly that a director could not defend an allotment of shares to himself as he himself participated in the meeting which made the allotment. So he cannot say, sir, this allotment which was not supposed to be made to me in this procedure was made and I do not know. So you can't say that, right? So if you have knowledge of irregularity, the exception shall apply. Even if there is suspicion of irregularity, this doctrine does not reward. Okay, that means you know that this transaction is a bit unusual, it is not in the ordinary course, or the person with whom I am dealing, I don't think he's authorized. Supposing I take a transfer of land from a cashier of a company. Okay, so that is obviously there is some problematic thing in that. I should take care of whether it is actually authorized or not. So if I could have discovered this irregularity if I made proper inquiries, but I did not do that, saying that it is a matter of internal management and I am here to presume that things have happened in the manner as if they had actually happened. So then I cannot take protection under this doctrine. Another important exception is forgery. Now, wherever forgery is involved, law does not support it. Okay, law is very clear about the nullity of forgery. So, a person who is dealing with the company cannot claim protection under this doctrine where forgery is involved. Now, transactions affected by forgery, we all know, are void ab initio. That means from the very beginning, they are void. Company cannot be held liable for the forgeries which are committed by its officers. Okay. Now, this case, Rubin versus Great Fingall Consolidated. Now, in this case, let us first go through this case law. Please take a minute and read this. Now, in this case, the secretary of a company, he forged the signatures of two of the directors required under the articles on a share certificate and issued the certificate without the authority of the plaintiff. So basically, the secretary, he forged the signature of two directors because this articles required their signatures and they were not available, and he issued them. Later on, the company refused to accept the person to whom such a share certificate was issued as a shareholder. Why? Because there were four signatures. So that person obviously will say that I did not know about your internal management. However, the law in this case said that we cannot let this fall under the exception now, because otherwise we'll be giving legal sanctity to the forgery, which the law cannot do that. So the law said that this certificate will be held to be nullity, and the holder of the certificate in this case cannot be allowed to take advantage of the doctrine of indoor management. Of course, he will have other legal remedies, but if we say that will he have this protection of doctrine of indoor management, the point is no, he cannot take that. Okay. Now also you can keep in mind that forgery can take different forms. Apart from the forgery of signature of authorized officials, sometimes if I execute a document towards a personal discharge of any official liability instead of the liability of the company, then also it becomes forgery. For example, if there was a decided case in which the manager, he issued a hundi to a person to whom he was personally liable, and that hundi was to be discharged by the company. The company will not discharge his personal liability. Why? Because the company is not supposed to do that. It was his personal liability. So that matter was discussed in this kind of a forgery also. So forgery, please keep in mind, is an exception to the doctrine of indoor management. Then suspicion of irregularity is also a very important exception, and knowledge of irregularity is also. So if I'm negligent myself, or if I'm very much aware about the irregularity, or if there is a case of forgery, we cannot say that there is any kind of protection which we can avail under doctrine of indoor management, right? Now let us talk about ostensible authority. Now, a company can always be held liable for the fraudulent acts of its officers acting within their ostensible authority. Now, what does this mean? Ostensible means obvious. Okay. So company can be held liable for the fraudulent acts of its officers who are acting within their obvious authority. For example, in this case, what happened? Under the articles, the directors had the power to determine who would be entitled to sign the contracts and documents on behalf of the company. So directors had this power to decide who is going to sign the documents and who is going to sign the contracts. So one of the director who was NP, he described himself as a chairman, though he was not authorized. Okay, so this director NP, he said that he is a chairman and he was not authorized. However, he executed and gave guarantee to the plaintiff in the name of the company. Okay, so this director, he described himself as a chairman. He was not authorized. He executed a guarantee and gave it to the plaintiff, and that too in the name of the company. Now, the plaintiff, he can't be expected to know all this, whether he was actually acting as a chairman, he was not authorized, and so on. So, it was very clearly held that if you're dealing with a director in the matter in which normally a director would have the power to act for the company, then you are not required to inquire whether or not the formalities prescribed in the articles have been complied with. So, company, again, for the ostensible authority, if the person is acting within his obvious authority, then you will always get proper legal protection. So, though this person was acting without proper authorization, it was held that you are not supposed to inquire into each and every formality which was prescribed, and you can easily presume that it was complied with. A similar case in this case was Sri Krishna versus Mondal Brothers and Company. In this case, the manager had the authority in the memorandum and articles to borrow, and he borrowed money, but he did not place the money in the coffers of the company. So he put that money in his own pocket. But whether the company is liable, yes, because he was its manager, the company was liable, and it could not refuse the plaintiff on the ground of fraud of its own officer. So the company said that since he is my own officer, I take responsibility, and for whatever frauds he has conducted, I assume responsibility for that. Okay. So with all these provisions kept and explained in a nutshell, I can conclude that now the articles basically contain rules, regulations, and bylaws. Okay. They ensure that the company's operations are managed correctly also, and that the company's objectives are effectively carried out. Okay. Because this is very crucial also for the understanding also and functioning also. So this document is also a very critical document. However, we have to keep in mind that these bylaws, these regulations, everything, they are subject to the company's charter, that is the memorandum, as well as the provisions of the Companies Act. Okay. The businesses can update these articles, they can amend them, but obviously we have read the restrictions, how we can alter the articles, what are the provisions we have to keep in mind while altering the articles. They should not go beyond the memorandum, not have anything illegal and all that. So we have to keep that broad framework in mind. Okay. However, if the articles are altered legally, properly, we have already read that the members are once again bound together in the same way as they were before, and the articles continue to bind them as if they were originally framed. With this, I conclude today's session, and I hope to meet you in the next session with a new topic. Till then, thank you so much.